now give the floor to the representative of Sri Lanka.
Mr. President, Sri Lanka congratulates Japan on its assumption of the chair of the Security Council in this first month of our new year, and Foreign Minister Hayashi Yoshimasa and yourself, Mr. President, for convening this meeting in a year of renewed hopes and dreams. A time when we will build back better a world structured on a social contract which the Leviathan recognized as a cornerstone of democratic political philosophy founded on the rule of law. Mr. Chairman, the rule of law is a critical principle, as we heard the whole morning, the whole day perhaps, and the cornerstone of governance. The modern concept of the rule of law is a fairly wide and therefore sets up an ideal of any nation to achieve. This concept was developed by the International Commission of Jurists, known as the Delhi Declaration in 1959, which was later confirmed in Lagos in 1961. According to this formulation, the rule of law implies that the functions of the government in a free society should be so exercised as to create conditions in which dignity of man as an individual is upheld. This dignity requires not only the recognition of certain civil or political rights, but also the creation of certain political, social, economical, educational, and cultural conditions which are essential to the full development of his personality. However, I'm compelled to, pose the question of whether the rule of law in this day and age is simply rhetoric or a universal principle. We know that international law, Mr. Chairman, is an existing and indestructible reality and offers the only hopeful foundation for an organized community of nations within the framework of the rule of law. This is well-founded and true. Those who best know the deficiencies of international law are those who also know the diversity and permanence of its accomplishments and its indispensability to a world that plans to live in peace. Our recent experiences could not fail to arouse among the community of nations a broader and deeper interest in the methods by which conflicts between states may be adjusted without wars and aggression. We thirst for freedom. We have twice in our lifetime disrupted our way of living, demoralized our economies, and menaced the security of life, liberty, and property on our planet, our only home, and presently on the brink of a third. The assurance of our fundamental laws that the citizen's life may not be taken without due process of law is of little avail against aggression or against the necessities of war. Isn't it now clear, Mr. President, I ask, that personal freedom, at least of the kind and degree we have known to us, is inconsistent with the necessities of total war and incompatible with a state of militarization to remain in constant readiness for one? Awareness of the effect of war on the fundamental laws of our nations should make clear to the peoples of the world the imperative and practical nature of our striving for a rule of law amongst nations. Everything we do, Mr. President, will fail unless we can devise instruments of adjustment, adjudication, and conciliation so reasonable and acceptable to nations that future governments will always have an honorable alternative to war. It has been said that the advancement of civilization does not diminish, it rather multiplies the occasions and causes of serious dispute among states. But they are less likely to break into war among people whose habits it is to regard peaceful ways of settlement as honorable and customary. We must encourage nations in time of threat and crisis to find it possible to accept alternatives to war only if their people consider that the peaceful alternative causes no loss of face. Governments in emotional times are particularly susceptible to passionate attacks in which this emotion is appealed to, sometimes by an emotional appeal to the notion of an impairment of sovereignty. It is observed that the work of the Permanent Court of International Justice has not been appreciated, but in a few but important cases that have been submitted to it. But to most of the nations and its people, such international tribunals, as we have had, were inaccessible professionally as well as geographically and bore little on the profession's work, day-to-day work and problems. While private claims based on alleged violations of international law or treaties are numerous, no permanent judicial machinery has been made available for their adjudication. We still leave the traveler, the businessman, or the owner of property in a foreign country who suffers a violation of international law or treaty rights in an unhappy position of having no sure or easy remedy, and the legal fraternity still thanks them as matters only for us diplomats. It has been said, it seems, that such hinges on acceptance of the concept of the court as an independent body above obligation to any nation or interest. We must appreciate that we as a global body cannot see how we as or any nation of like philosophy could submit a dispute to a court otherwise conceived, or certainly could not concede any measure of any compulsory jurisdiction to it. Jurists have observed that we can have nothing in common with the cynics who would have us avoid disillusionment by having no ideals, who think that because they do not believe in anything, they cannot be fooled. We must keep the faith, as observed by Chief Justice Coke, that even the king is under God and the law, for it is the law that makes him a king. Let me briefly turn to our courts. Mr. Chairman, we must bear in mind that it is futile to think that we can have international courts that will always render decisions we want to promote our interest in. We cannot successfully cooperate with the rest of the world in establishing a regime of law unless and until we are prepared to have that law sometimes operate against what would be our national advantage. In our internal affairs, we have come to rely upon a judicial process to settle individual controversies and grievances, and even those between nations, not because courts always render right judgments, but because consequences of wrong or unwise decisions are not nearly so evil as the anarchy which results from having no way to obtain any decision of such questions. The alternative is to take the case law into our own hands, and in a somewhat similar spirit of accommodation, we must look upon any international tribunal not as those decisions always are welcome, but always right or wise. But the worst settlement of international disputes by adjudication or arbitration is likely to be less disastrous to the loser and less destructive to the world than no way of settlement except war. As we will not suffer the worst of decisions, but will benefit from the judicial process at its best if we insist upon the independence and intellectual integrity of an international tribunal which seeks to adjudicate or arbitrate between states. Mr. President, finally, the General Assembly is entrusted with the crucial responsibility of promoting the steady advancement of international law and its codification under Article 13 of the United Nations Charter. The United Nations have been successful in significantly strengthening the rule of law on a global scale. We stress that the laws are only as effective as how they are implemented. Additionally, implementation is only as good as the fairness it is based on. Sri Lanka therefore reiterates its call for systems to ensure a fair and just application of laws and the principles agreed upon by member states of the United Nations, including the principles enshrined in the Charter. It is said that governments can easily exist without laws, but laws cannot exist without good, responsible government. It is confidence in the men and women who administer the judicial system that is the true bedrock of the rule of law. It is incumbent on all states that seek to establish and entrench the rule of law to develop, sustain, and nourish the human resources vital to the ensuring of the rule of law amongst nations. Let us today pledge to commit ourselves to that ultimate goal. I thank you, Mr. President.
I thank the representative of Sri Lanka for their statement. I now